Someone make it make sense.
Probably a couple.
Hello, everybody. How are you doing tonight? What a wonderful word is hello. Yes, indeed. Yes, indeed. Squirrels of the world. Hello, my friends. Happy to see you. So, what's up, everybody? DSM, where are you at in the trial? I haven't actually been on Discord since like earlier today. So, very curious how you're coming along. Candace, are you sore after your run? Black Witter, how are things with you and fucking Andrew? How's everybody doing? We haven't done this one in a while. Hold on. It's just right or wrong here.
Hey, he's got a bird in his mouth.
There's a chicken.
It's a guinea.
It's so cute. It's so cute how you can hear them in the background. It's just so cute. I love it so much. Y'all, so last night was epic. We finished Amber Heard on the stand, round 1, because she does come back again. Can't get rid of her that easily, huh? And that was day 17, most of the day. So I'm wondering where DSN is at this juncture. Probably finished 17, probably started day 18, I would think. I don't remember who testifies on day 18. I think I looked it up in Spiegel as day 20. So, but yeah, so hope you guys had a good day. That's right, Candace, like a bad cold. She comes back again. That's absolutely fucking right. Yes, indeed. DSN, did you hear your sounds? I'll do them again just in case.
Hey, he's got a bird in his mouth.
There's a chicken.
It's a guinea.
I love it. Freaking love it. Gang's all here. Speaking of gang. Shout out to Steve Planner, girl. Oh, it's so good. So yeah, so I do have some news. So, okay. Homework assignments that I had since last night. So, I did figure out, it's the Shrimp Weasel. I did figure out how to do the thing on Discord where you can share a movie and they not give you any issues. And so I learned that one of the main things about the difference between like the voice, or sorry, on Discord, the difference between like text channel and the video or the voice channel is like text channels are only texting, which I know might seem like common sense, but like, I guess the reason I'm saying it is because voice channels are not, it doesn't mean only for voice, right? So like anything that's not just text is voice channel. So for example, my point being, even if you don't want to use your microphones, but you want to share a screen or watch something with your microphones muted, that would still be a voice channel. So there's that. And I did learn all the steps to do it. The only question I still have is like, if you do talk, will people be able to hear each other in the movie? And my thought is probably not, if I had to guess. So I think what we would do is use the voice channel because you would have to, and then just have everybody muted, right? More than likely, just because I don't think it would work otherwise. I mean, I could be wrong. Well, I mean, you know, I'm probably overthinking it. Like, we could always test it out with like microphones on if people want, whoever wants to, right? And then if it's like no one can fucking hear anything, then we mute them. You know what I mean? Dr. Bob, dude, I have been thinking about you every day that you've not been here, and I've been wondering if you've been okay. And I'm so glad you're here. Because I don't like here's the thing. Nobody has to be at every stream, obviously. Goes without saying, right? So I always feel like when somebody's like usually here and then they're not, then like, you know, I don't want anyone to be like thinking like I'm like, where are you? You know, because that's not what it is. It's just that I worry. So I have to, I'm always like, literally, I'm just explaining my thought process is that every day that you've been gone, Dr. Bob, I've been like fighting with the idea of like, should I reach out to Dr. Bob, or like, is Dr. Bob going to be like, dude, I don't have to be at your live streams, which of course you don't, you know, anyway, I don't know if that makes any sense, but like, I just wanted to say, I've been worried about you and I'm glad you're here and I hope everything's okay. It looks like your dog. No. Okay. Oh my God. I swear to, if something happens to your dog, I don't even know what I'll do. I can't handle that with dogs. Oh, I'm so sorry. Bandit. You guys, everybody send your positive thoughts, vibes, prayers, hugs, all the things that you have, send them all to Bandit. Here's Bandit. I'm so sorry. I understand. I've been there. There's nothing so horrible in the whole world, in my opinion, as having a dog that's sick or injured or hurt in some way. It's just beyond. It's absolutely beyond. I'm so sorry, but I'm glad you said he's turned a corner. I'm glad you're here. I just know that, again, just for everybody, guys, right? I don't, you know, if ever I ask, hey, are you okay? Just know that it's not because you have to, like, you know, just know that I love all of you guys. And I know I keep track in my mind of literally every single person who's ever been here. Even if they've been here one time, I remember them like a crazy person. And so then I always remember them if they come back. And then I notice when people aren't here, and it's like, just because I love everybody, it's just in my mind. It's like, oh, I hope they're okay. So, you know, oh my God, I'm so sorry that you thought that's, by the way, Dr. Bob, I don't know if you've been here when Abby's been here, but Abby Giss, who's in the chat oftentimes, she's a squirrel friend. She's also a vet. So I don't know if ever you have any questions, I'm just throwing it out here that she would answer them for you. She's an amazing person. She does like the emergency vet clinic. I think she works at 2 of them. And she's, anyway, just to throw that out there. Because I know what it's like to not want to bother your vet with questions. Like, again, I've been here, you know, and they're like, you know, you don't want to call them like every hour. So anyway, just to throw that out there. We do have someone who is very good with animals and has a lot of experience as a vet. So, yeah. So I'm sure she would be happy to answer any questions that you have. I'm sure she would be happy to help. In fact, we consult her even with questions about human health issues because we don't have any like human doctors really. Actually, I think she's the closest one because I think she also had experience as an EMT, which makes sense, right? She's just that type of person. Emergency health for humans and then emergency health for dogs, right? That's her. So all of the hugs for Dr. Bob. Wow. Hey, maybe it'll cheer you up, Dr. Bob. We have a new command for Nightbot. If you type exclamation point and then 5, like spell it out. So exclamation point FIVE. He might cheer you up a little bit. Oh, Bandit. Bandit will pull through. He's strong. He's a good one. That Bandit. Oh. Love it. Dr. Bob's testing out the new command. I think we have more than one, but that's one of the best ones, I would say. We have also, Dr. Bob, we have some new squirrel friends that are awesome too, since you've been here. Nightbot is good like that. Yes. What do you think? Do you like it? Isn't it just so cute? I love that Nightbot. But yeah, we have some new squirrel friends that have joined and they are awesome. I'm excited for you guys to meet each other. And we've had some other fun ideas. So one of the things that I was going to say is we want to do like a movie night. And I figured out how to do that through Discord, which is what I was saying. So I think I think what I was saying is like that. I'm probably overthinking it because we could just as easily have our microphones on and then turn them off if we can't hear it. Anyway, but I think I figured out how to do it. So we can watch The Room. And so that was one thing. The other thing is I started looking into programs for the Squirrels of the World idea. And I think I found a couple different applications. I just have to test them out, but I think I found a couple different applications I can use that'll let me do squirrel icons as pins. So this idea, Dr. Bob, was Squirrels of the World. And it was like this idea where we have like an interactive map where for anyone who wants to, right? You don't have to, but for all the squirrels that for both the US and the world, right? Wherever there's a squirrel, it drops a pin, but the pin is a squirrel. And then we had the idea to do a live stream at some point where, you know, again, it would be a voluntary thing, but where we go through and we look at the maps and then we go through where everybody is. And I added a new thread also in the Discord for that called Where We Live for anyone who wants to just show pictures. Again, you don't have to put your address, obviously, but just whatever it is, you know, it's just fun. Fender has had some crazy stuff happening. Like she got her promotion and her thesis got published in Science Direct magazine. And she had some crazy monkey stories happen. Candace ran her half marathon. We've had a lot going on. It's been awesome. I saw your command, Black Witter. I saw it. I'm pretty sure. Did it do it again though? You got to be joking me. That would be wild, isn't it? Let's see. I thought I saw it though. Wait, maybe not. Weird. What is going on? That is very weird. Because it was working yesterday. So also, for those who aren't, YouTube seems to be having issues. StreamYard has had issues, but it seems like they've got those worked out. But anyway, I don't know what's happening. DSN is lying. Don't let anyone fool you. Don't let DSN fool you, Dr. Bob. He has been doing stand-up comedy in the Discord. And if nothing, dude, I told him if he does a stand-up show, I will come from North Carolina. And I'm sure I'm not the only person. I guarantee you he will have full support of people. Like, seriously, it is amazing. Highly recommend. He tells his jokes on there. It is amazing. And Dr. Bob, Black Witter has said some stuff on there too. If you want to hear her beautiful Irish accent. Oh, it's so good. So much good things. So many good things. And what have I done? Well, I've made a couple new things. I've made, well, we have this, right? Which that's not a new thing, but it's new to have it on here this way, the Shrimp Weasel. We've got an update to this scenario where we've got Amber Heard. Again, road trip crew, Lally's not invited. And Lally is trying to get away from Amber Heard. So that makes sense. Then we have this. This is the Rhinoctopus, because according to Amber Heard, the only way Johnny would have been able to do things she says he does is if he has at least 8 arms, really, and is a rhinoceros, among other things. And I'm also working on the Elaine hybrid. I'm gonna go with an ostrich and T-Rex arms. I'm already working on that too. So I'll have that for tomorrow. Not, dude, don't sell yourself short now. Her accent is exquisite. Don't let anyone tell you otherwise, Black Witter. So we also did a live stream touring Karen Reed's house for sale. And actually, Dr. Bob, I did mention you. I was like saying, like, you should sign up for a tour because you can tour the house since you're local, you know, half joking. So, right. Yeah, that's right. Bottle for a horn. Yeah. So what else? I feel like there's been so many other crazy things, man. Oh, we learned that, for anyone who hasn't heard this, that Amber Heard is living in Spain under the name Martha Jane Cannery, which is Calamity Jane. So she's just stealing from Calamity Jane now. He does have a great voice. Both you guys have great voices. I love everybody. I love y'all's voices. You guys are great. It makes me so happy to hear you guys in the Discord. And like, I love, like, it's like every time I check, pretty much I see like there's a new joke from DSN. It's just amazing. Like DSN, you're brightening everybody's day, just to let you know. I don't know. Dr. Bob, do you know that we went back and did, well, wait, hold on. First of all, the first things first. Dr. Bob, did you know that DSN had never seen Depp be heard? Actually, he's not the only one. Neither has Super Planner Girl. And then second thing, that DSN has been going back and watching the entire trial gavel to gavel from the very beginning, just recently. And that third thing, once he got to Amber being on the stand, I was like, yeah, well, you know what? We're going to watch this together because we can't not. And so I've been going back and doing Debbie Heard again with the sidebars. Black Widow, that's, you know what? That's fine. That's all good in my world. She says, maybe we all sound like lawnmowers, but we just love each other. Totally possible. And that's okay with me. So yeah. So then, so we went back and we've been watching, we watched all of, yeah, right. I know. That's right. No squirrel left behind. Well, all the hugs to you, Black Widow. I know it wasn't. Hey, did the seagull ever show up last night? We were all worried about him or her. I think it's a him. Do we know? So he's making his way through it real quick, Dr. Bob. It's amazing. He's on day 18. Wow, cool. Only 2 more days to Dr. Spiegel. Did you say to Andrew about the seagull or about no squirrel left behind? Or both? I hope the seagull's okay. That was the other thing. So like last night, I was like extra worried about Dr. Bob because Dr. Bob hadn't been here for a little bit. And I was also very worried about the seagull. So day 18, what witness are you on? Because I can't remember who's on day 18. Is it deposition still? Oh, the seagull. Okay. She says. So did Andrew hear him? Or no one heard the seagull? Oh, I hope he's okay. Oh, right. That's right. Yeah, I agree, DSN. It is the best case towards her claims. Yeah. Mm-hmm. I agree. Yeah. Black Widow says she despises Amber Heard more than gastroenteritis. Yeah. Makes sense. Makes sense to me. So I'm trying to remember who's after Rocky. I think there's maybe, wait, is she the last out of the Amber Heard ex-friends? She might be the last. So you've already heard Io, I think. And then it's Rocky's ex-husband. And then I heard DSN. I heard Amber Heard defamed gastroenteritis and made some allegations regarding sexual abuse that didn't happen. That's what I heard. So yes. So what else? I feel like a lot has happened though. But I'm excited for when DSN gets to Dr. Spiegel and the Morgans. But it's so funny because last night I was like, you guys, I wonder if tomorrow we're going to get this response, right? Well, turns out it had come out, but literally I did not know about it. I don't think anyone knew about it. What I noticed happen is this. What was it? 2 days ago that her house went up for sale on the market. And we did our live stream on that. And like, not really anybody was really talking about it that I saw. And then yesterday, every time I went to look for updates, everything was about the house. So everybody was a day late, right? Everybody was talking about the house that I saw. And what happened, to my knowledge, again, from what I saw, was that this response came out, but everybody was talking about the house. So anyway, so I have actually not even read it all the way through yet. We're going to do a first look situation, so it'll be exciting. And what I did was this. Hold on, let me zoom in. Make it better. Well, we don't need it that. Okay, that seems to be okay. So here's what I did. I made a little video, as I want to do. I did not hear this. Really? You say was. Does that mean before the defense filed their motion? Like, does this mean a new judge was going to handle the hearing and then after this motion it changed? But I did not hear that, no. Okay. I'm assuming that they're going to address this motion then. However, as we know, it was scheduled as just a pretrial conference. Now, a couple thoughts. Either way, if it's a pretrial, scheduling conference, right, where the Commonwealth might decide if they want to retry whatnot, or if it's to hear this motion, the defense's motion, either way, if Judge Bev is not hearing it, that is very interesting to me. That's actually huge because that is wild. My brain's going to take a second to buffer this. Okay, she was scheduled to handle it. So I don't know what this means then. She was scheduled to handle it when it was just the pretrial conference or what? Maybe I should just Google it. Let's see. As per usual with the algorithm, I do a search and it doesn't come up with anything related to what I'm searching for. I can't, dude. I don't know. I would have to it would take me a bunch of tries of searching in different ways to get an answer because of the algorithms. So if anybody knows the scoop, please let me know in the chat. I'm curious what's going on with that because that's a big deal, regardless of what, unless there's like, okay, unless she's got some sort of surgery or something, right? Like, or something happening. But it's interesting because either way, let's say that they're just going to talk about a status conference, right? I mean, if you're talking about that, that's the calendar. You kind of need the judge there. That would be overseeing it. And then if it's the motion, right, you need the judge there who's going to be handling it. So either way, yes, Blackwater. The TikTok psychic, Idaho. That's frivolous. I haven't been covering that, but I could. That's a good one. That's a good one. So what I want to know is why is she not doing it? I mean, it's great. Why is she not doing it? And also, when was this decision made in terms of, was it before or after the defense's motion? And third question is, did they talk about if they're going to address the motion at that July 22nd hearing? Those are my three questions. If you're interested in hearing Blackwater or anybody about a quick synopsis of the TikTok psychic, let me know. I mean, in a way, I definitely heard it's frivolous, but also in a way it's not. It's like half and half. we've gotten past the heavy part, right? In terms of like Amber on the stand with some of that testimony is the heavy part, especially for those who have survived any type of abuse. And really, apart from that, it's really more just frivolous to me. That's how it reads. That's what it feels to me. The rest of it is just frivolous feeling, right? And so it's exactly what Blackwater is saying she's in the mood for. You're afraid to say yes that you've heard of the TikTok psychic? Again, it's another thing where it's like, it's terrible what she's doing, but at the same time, it is frivolous, right? Like, let me think. Okay, I'm trying to think. There are cases that are literally, there's really nothing heavy and they're just frivolous, but they're harder. There's not as many, obviously, right? So even if you've got something that's civil, right, like defamation, which is the TikTok psychic, or Depp be heard, there's going to be some element probably of weight to it because it's a case. But it's like, if you compare it to other things, right? You compare it to Karen Reed, for example, you know what I mean? It's all relative. Thank you, Dr. Bob. He says it was made before the second response was filed, but most people think it will just be for the status conference. Okay. Gotcha. I totally get it. Yeah, see that type of stuff, small claims court, we're not going to be able to find court documents on that because it's not going to be, and it's not going to be televised, right? Unless it's on like local TV. We have done the select board meeting. We've done 2 of them, actually. Was there another new one, Blackwater? Is that what you're referencing, like just recently? Because if that's the case, then no. Let me do Google search real quick. There's July 9th. No, I don't think there's been another select board. Hold on. No, I don't think there's been another select board, unfortunately. Yeah, it looks like it's still June 25th and July 9th. That's on their thing. Yeah, but I think you were there, Blackwater, when you missed it? We watched both. Are you I thought you were there. Yeah, so we did. We watched the first 2. Well, not the first 2, the most recent 2. And then we switched over to the police. We didn't finish that one though. Though it wasn't the police commission or whatever. I'm looking on their website. I'll look again. So it says live on the government TV station and streamed live planning board. That's today at 6:30. But that's not the select board. Oh, here's a schedule thing, I think. Okay, live coverage for the week of July 15th through 21st. Monday, July 8th, Tuesday, Wednesday. So Tuesday, July 9th was the select board. That's the one we watched from last week. And then, yeah, there's not been anything new. So I don't know what it is that they posted. That's interesting. If you guys want to look and let me know. But they do have the schedule on there. The most recent thing they had for live programming actually would have been after they updated the schedule, but it would have been the thing I just mentioned, which is the government TV station and streamed live planning board. I don't know what that's weird. I don't know what the heck that's supposed to mean. We could look at that. That happened at 6:30 tonight. That might be what it was, but it's not the select board. Oh, thank you, Dr. Bob. I want to know why she's there temporarily. That is interesting. So let's do this. Oh, cool. That's neato. That automatically shared it. Okay. So, look, no, wait, here. This is what I was saying, guys. I just wanted to show y'all so that you could see what I was doing. I don't know why I wasn't sharing my screen. I was just looking on my phone. Okay, so this is the one that just happened tonight. This is the most recent one. And then, like, other than that, if you go to, so that has its own separate link because, you know, they make everything complicated. Now, if we want to watch it, I have to share my screen differently or it'll echo. But actually, yeah, so here you can even see there's the most recent select board. There's the zoning board. I think we watched a little bit of that. See the entire schedule. Here you go. So the most recent thing apart from tonight would be July 11th, the zoning board, I think. Because obviously it just repeats everything over and over. So if we want, will it even let us? Because this just happened. I can't even tell. Are they still live with this one, I wonder? Anyway, but I have to share it differently if we want to watch it. So Dr. Bob says Rayburn is known for successfully prosecuting Michelle Carter. Okay. So yeah, I don't know. It's interesting. Okay, here's what the plan is though, guys. So I made a little video, y'all. Like I said, I haven't actually read through all this. It's going to be a first look, but here's what I did. I made a little video with some key points from when I covered the Commonwealth's opposition. And this was what I thought potentially the defense might argue, or what I would do. Also, I just have to say, I have a lot of thoughts about all this. There's a lot of people with a lot of different opinions. And I see so many things that I'm like, why is nobody mentioning this? So anyway, if you're curious, you can ask questions or whatever, you know. There's some of you guys might have heard things in other videos, but, you know, I don't assume everybody's watched every video. But anyway, I guess I could talk at great length for hours about my thoughts on all of these filings that have come out. So, but anyway, let's start with this video that I made, which is just it's very short. It's just a couple of the key things from the live coverage I did. And this was when I did a first look at the Commonwealth's opposition. And this was going through it with you guys live. And if you guys remember, I was like really in the zone. And I was like, my automatic gut response and gut reaction of like, if I were the defense, I would do this. If I were the defense, I would do this. So I don't know yet what's all in this filing. So it's a game, right? We're going to watch the little video and then we're going to see if they say anything that I said or if I was just completely wrong. Okay, so let's take a look. So hold on, let me back this up. Okay, it's been a while since I've done a video file. Let me start this again. So how might the defense respond to the Commonwealth's opposition? Let's consult the Squirrely crystal ball. Yay! So this is from July 12th, 2024. I think what will matter here, by the way, this live stream, I did this literally, this was that same Friday. That was so crazy. It was when Baldwin had a mistrial and everybody was covering Baldwin. And this Commonwealth opposition came out literally probably an hour or something before we went live with it. So that's what this is from. This is from Friday, July 12th. Is the specifics of the case. Like I said in that video that I made, right? Remember? And like IFRAC, right? The issues, that's the legal issues, and then the facts. Because let me put it this way. We don't know that this, whatever case this is, there might have only been one charge. And that's a completely different situation. For example, if there was only one charge and then the jury comes back and says they're deadlocked, then yes, there's no need to inquire about what, you know what I mean? It says here, the foreperson unequivocally stated that the jury were unable to come to a unanimous decision, that they were deadlocked, right? But this doesn't say that there were multiple charges. I'm sure the defense will point all this out in their response. In my opinion, of the four issues they stated here, the key thing, famous last words, right? I just said, I'm sure the defense will point all this out in their response. So we'll see. Only one, actually, I can quote Johnny from the room. We'll see about that. There's a long awkward pause. And then he says it again. We'll see about that. Anyway, if you haven't seen it, you're probably like, what the fuck is happening? But if you've seen it, you're probably laughing. They stated here, the only one that holds any water is this one that is in huge dispute, large dispute, that the defendant consented to the mistrial. That's the one where there is contradicting case law. The rest of these issues, of which they stated 4, they did not prove, in my opinion. Massachusetts law to the contrary clearly permitted the jury to return a partial verdict on some but all accounts. And that there's 27B. Now, what's interesting is they didn't cite it for the part that I think is the most important. I mean, what do I know, right? But like they did cite, they at least though did cite it. And where they have it is a footnote here. Declining to require court to consider the jury new options for a verdict in the form of partial verdicts unless they're included offenses, where under Arkansas law, the jury's options were limited to 2, either convict on one of the offenses or acquit on all. And where they say Arkansas, they're using Blueford. So they're using Blueford here to their advantage to say this isn't like Blueford. The Commonwealth is going to cite Blueford, and Blueford just does not apply. And again, remember when I was like, oh yeah, didn't the defense cite Roth? There we go. So let's look at this because this is interesting because they have here, like Roth is an example where they both cited the same case law and are using it for different reasons. So let's look at this. So here where they're citing Roth, such inquiry in effect implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return 3 separate verdicts on 3 separate counts. This is important because that's literally the language she used in the jury instructions. Okay, and then here's the quote from Roth: distinguishing situation where a defendant has been charged in separate indictments. You guys, sometimes I'm like, wow, am I psychic? Because remember when we looked over that, what did I say? I complained because I said, well, this is ambiguous because it looks like this defendant could only have one charge, and that's different from when you have multiple charges or multiple indictments, right? If you only have one indictment, then yes, it would be irrelevant to say, can you come back with a verdict on any of the counts? Because there's only one. And they've already cited Roth saying this works in our favor because it's saying a distinguishing situation where a defendant has been charged in separate indictments, which Karen had 3, has 3 still, or complaints each with a separate verdict slip. That's the case here. Let's go back to the Commonwealth and see what they cited for Roth again. Here, this is the one I was up in arms about, right? to quote, Phil Waters had my panties in a wad over this because of that reason. So that's so fucking funny. So the Commonwealth cites the same case law and leaves out the part that is relevant.
Crazy.
Because it's the part that says if there's more than one indictment, it's different, which is what I literally said, just based on the fact that this logically doesn't make sense, right? You guys see what I mean? Like, that's really crazy.
It's a house.
Yep, sure is. Sure is. Sure is a house. So, all right. Without further ado, let's see how much of that is relevant to what the defense said. So let me share my screen again. And let's go through it. And just as a reminder, this was not written by Jackson Unetti. It was written by Marty, what is his last name? Weinberg. Oh God, what's his last name? Hold on. Weinberg, officially, it's Weinberg. It was written by Marty Weinberg, not Jackson and or Unetti. But he also wrote the motion, the initial motion, right? He also wrote that. So same guy. Alrighty, so let's just take a look. Defendant Karen reads, I love how each time something happens, the names get longer. It does make it for a challenge every time I make a YouTube video and have to try to fit it within the character limit for the title. Defendant Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. Like that in and of itself would already be past the limit of YouTube character title limit things. Now comes the defendant Karen Reed by and through. I wanted it to scroll. I forgot that this is okay. I forgot that the scrolly bar makes it zoom. Okay, let's try this again. Now comes the defendant Karen Reed by and through undersigned counsel and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps, okay, let me say this again. The Commonwealth's opposition is perhaps most notable for what it does not dispute. That, according to information from 4 deliberating jurors, the jury had reached a unanimous decision that Miss Reed is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. The Commonwealth's insistence that Miss Reed must nonetheless be, quote, forced to run the gauntlet once more is based on several clear fallacies. And we have a site here for Green v. United States. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, for example, the appropriateness of a Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. Interesting that that's hyphenated here. For anyone that missed it, I timed that out. 4.65 seconds was how much time anybody had, including the Commonwealth. Rather, upon receiving the final jury note, the court, sua sponte, declared a mistrial with no warning to or solicitation of objections from the parties. Second, the jury's note did not explicitly indicate an impasse on all charges. To the contrary, it was readily susceptible to the interpretation proven correct based on information received post-trial from deliberating jurors that the deadlock applied only to the multiple offenses included within count 2 and not to counts 1 and 3. So first of all, that was a really long sentence. Second of all, I can't help it. I have to see what this case law is. It's just the way that it is. So let's take a look. Freaking love case law, man. So I need to make a new window. Aha, perfect. All right. Interesting. Interesting. So the petitioner was indicted and tried in a federal court for first-degree murder. The judge instructed the jury that it could find him guilty of either first-degree murder or second-degree murder. The jury found him guilty of second-degree murder, and its verdict was silent on the charge of first-degree murder. Interesting. The trial judge accepted the verdict, entered judgment, dismissed the jury, and sentenced the petitioner to imprisonment. On appeal, his conviction was reversed and the case was remanded for a new trial. On remand, petitioner was tried again for first-degree murder. Oh, that sounds like double jeopardy. Under the original indictment, convicted of first-degree murder and sentenced to death, notwithstanding his plea of former jeopardy. Held. Petitioner's second trial for first-degree murder placed him in jeopardy twice. There it is. I was right. Yeah. Placed him in jeopardy twice for the same offense in violation of the Fifth Amendment, and the conviction is reversed. Wow. So this is on point. This is on point. That's why they cited it in the very beginning. Petitioner's jeopardy for first-degree murder came to an end when the jury was discharged at the conclusion of, that's why they cited it. So the issue, okay, this matters. I'm glad I looked this up. Here's what they're talking about, guys. What seems to be one of the things that will be at issue is, can a jury render a verdict once they've been discharged? That's what this is coming down to. And that's why they cited this case law. Well, first of all, it was already on point, but additionally for this part, petitioner's jeopardy for first-degree murder came to an end when the jury was discharged at the conclusion of its first trial, and he could not be retried for that offense. By making a successful appeal from his improper conviction of second-degree murder, petitioner did not waive his constitutional defense of former jeopardy to a second prosecution on the first-degree murder charge. In order to secure the reversal of an erroneous conviction of one offense, a defendant need not surrender his valid defense of former jeopardy on a different offense for which he was not convicted and which was not involved in his appeal. So this was a federal murder case. Interesting. Huh. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity. As well as enhancing the possibility that, even though innocent, he may be found guilty. Okay, I'm going to leave this up just in case we need to refer back to it, but let's go back to this document. So I wanted to read this really long sentence again. Okay, to the contrary, it was readily susceptible to the interpretation proven correct based on information received post-trial from deliberating jurors that the deadlock applied only to the multiple offenses included within count 2 and not to counts 1 and 3. Third and finally, the defense respectfully submits that neither the Commonwealth nor the court, quote, carefully considered alternatives before declaring a mistrial. Yeah. One alternative I could think of would be asking the jury if they had a verdict on any charge, aka following Rule 27B. That would be one alternative I could think of off the top of my head. The record reflects no discussion of any such alternatives, including, importantly, inquiry. Keep reading, Chelsea. Inquiry regarding whether the jury had reached an impasse, right, on all, as contrasted to just some of the counts. Yeah, okay. The underlying idea of the constitutional protection against double jeopardy, one that is deep. Wait. Didn't I just read this? Holy shit, that's fucking hilarious, you guys. Wait, hold on. I just read this. Remember this? Sorry, just thinking about old Greg. Remember the boat times? Remember this time that just happened literally 3 seconds ago when I read this paragraph right here? And I was reading it because I was like, wow, that looks relevant. Oh, well, we're back to the boat times. Shout out to old Greg. Oh, boy. The underlying idea, they actually cited this. That's wild. The underlying idea of the constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for alleged offense. They didn't read the end of it, though. We did. We did it. This part. Where was it? Thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity. Anyway, even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. That's a good one. Let me read that part again. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. That is a powerful sentence right there, man. That is a powerful sentence. That, whenever anybody asks what double jeopardy is, I think this is a really succinct way to put it, to sum it up, where it gets to the heart of what our constitutional rights are and the role of the government. That's what it comes down to, because it's like you can explain how and when it attaches. This is what matters. I'll read it another time, last time, probably. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. That is powerful. That's powerful to me. Oh man, right? That's fucking funny. Yeah, right? It's so true. We don't see them. Yeah. Okay, so then here's this case law. And they actually cited some of this before. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution compels the same result: dismissal. Let me read that again. Thus, they're saying the thus here, okay, the thus here is based, they're saying in constitutional rights, okay, based on this case law, like we were just reading. Thus, whether the jury acquitted Miss Reed or, so this argument here, here's why this matters. Because they're trying to get ahead of this idea of was she really acquitted on those counts? Because there's still a lot of things that are at issue. Will they be able to ask the jury? When is it too late, too bad, so sad? We still don't know if any of those forms were even filled out. And if we don't know about that, right? Because they could have filled out the forms and just not said anything, because remember, they have to verbally give a response. Anyway, like it could be that they filled out those forms for counts 1 and 3 and didn't fill out count 2. It's possible. Well, no, we don't know. So what they're saying is this. They're trying to get ahead of this whole thing of like all these different issues and be like, that's splitting hairs, man, because here's what it is. Thus, whether the jury acquitted Miss Reed, as in, let's just say that we're right and all these jurors that have come forward are right and everybody was unanimous that she should have been found not guilty on counts 1 and 3. And let's just say that this is a reversible thing that can be fixed and blah, blah, and, you know, our motions can be great. Like in other words, best case scenario, right? Let's just say that, but not even that. Alternatively, let's just say that the jury was merely not deadlocked on the relevant counts. So whether she was acquitted or merely not deadlocked on the relevant counts, the Constitution compels the same result. So again, this matters. This matters. This is argument now. This is argument. This is argument. Okay. But it matters because it's a good argument, I think. They're saying, again, let me just reiterate, whether the jury did unanimously find her not guilty on counts 1 and 3, or even if that wasn't the case, even if they weren't unanimous, but let's just say they weren't deadlocked, right? The Constitution compels the same result, dismissal. Given the unambiguous post-trial evidence, it would simply be wrong to require the defendant to obtain 2 acquittals from 2 different juries for the same crime. So hold on, let me think this through real quick. So, right, and again, I think the point here is that if they're only deadlocked on 1 count and not deadlocked on 2 others, right? Those would be the relevant counts. So given the unambiguous post-trial evidence, it would be simply wrong to require the defendant to obtain 2 acquittals from 2 different juries for the same crime. Okay. Next page. Okay. The Commonwealth's leading argument is rooted in pure formalism, that no verdict was entered on the record in court. And then that's the opposition. Opposition is referring to their motion, the Commonwealth's opposition, right? So it's citing that. I can actually, I've read it. I can actually, we don't even need to pull it up. I can tell you exactly what they're referencing here. What they're saying is they're referencing the part in the Commonwealth's opposition to the defense's motion to dismiss, that this would be the argument where I actually got really annoyed by it, because they were saying, the Commonwealth was saying that if you fill out the verdict forms, do you guys remember this? They were saying if you fill out the verdict forms, that doesn't even matter. Like, dude, this is so insane, right? They're like, that doesn't even matter. You have to say it verbally with your mouth if you really mean it. And that's the only verdict that counts. I was like, you've got to be fucking kidding me. What are we even doing, guys? That was so annoying. That's what they're referencing when they say opposition at 5, is that part. But precisely this formalistic mode of analysis has been consistently rejected by the United States Supreme Court. I'm not surprised by that. And Supreme Judicial Court in a string of precedents spanning more than 100 years. Now, remember what I've said, guys. So many of these live streams where we're doing case law. What do we talk about? Binding, mandatory binding authority, right? So remember what I said. Actually, I think I said this on the last video or the last live stream where we were reading this opposition. Remember what I said? I said, whoever can bring in U.S. Supreme Court case law that's on point wins. That's your mandatory binding authority. Whoever can bring in United States Supreme Court case law that's on point wins. And remember, if it's not on point, it does not count. So that will be the thing. So here they don't, well, okay, they are citing case law, but it seems kind of vague. It says this formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. And then here's the citation. The reception of the verdict and discharge of the jury is but a ministerial act involving no judicial discretion. However, it may be in England. In this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. I don't know what the fuck they're talking about in England. You guys, what the fuck? Holding that judicial grant of a new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize trial judges to enter judgments of acquittal in jury trials. Oh, interesting. Indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges. Holy fucking shit. This is interesting. Holy fuck. This is the history of how it happened. Wow. Okay. That's why it mentioned England. The abhorrent practice of English judges exercising a power to discharge a jury whenever it appeared the Crown's evidence would be oh my God. Okay. Let me, what's the word? Summarize this. So what they're saying is that the reason double jeopardy, the way this came about is because what happened was the crown, aka England, right? You know, back in the day, back in the good old days, not good old days, whatever. Depends on, you know, I guess your outlook on life or something. That's, you know, anyway, back then, the beginnings of the country. So that is wild, man. This, when you think about this, this makes a lot more sense, right? Of how we get to where we are today. Whenever it appeared that the Crown's evidence would be insufficient to convict, the Crown would just discharge the jury and start again. Dude, that's wild. So in other words, this whole thing about discharging a jury and it having a mistrial seems like it started with fuckery, right? It started with fuckery because they realized the jury wasn't going to convict because their evidence sucked. Does that sound familiar, guys? And then what would they do? They would discharge the jury and start again. And so that's how double jeopardy came about, was to stop that fuckery from happening. Wow. Insane. The Commonwealth's heavy reliance upon Blueford v. Arkansas fails for reasons set forth in the defense's opening motion. In that case, after the foreperson reported that the jury was unanimous against conviction on certain charges, the jury was sent back to continue deliberations. Quote, the foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. So what was that footnote? Hold on. Footnote 1. Where is footnote 1? Oh, there it is. Oh, that's the part we were just reading about the Crown. It was insane. Okay. The Crown's evidence. Interesting. This actually really matters right here, guys. Check it out. All right, let me zoom in on this footnote. Wow. So remember when I was just making fun of the Commonwealth with their stupid thing? They're like, yeah, the verdict forms don't matter. The jury has to say the verdict out loud verbally. It's like, what the fuck what is happening? So this case law here says, quote, a verdict which has never been spoken by the jury cannot be implied from the mere omission of the jury to contradict the statements of the clerk or from the silence of the prisoner and his counsel. Again, this is supporting that argument that just because they were silent doesn't mean they consented. In any event, state law requirements are not binding as to what constitutes an acquittal under this United States Constitution's double jeopardy clause. Interesting. That also works in their favor. Well, obviously, that's why they cited it. So, okay, so next page. All right, so all 12 jurors believe the defendant was not guilty. Right, okay, they were talking about Blueford. Okay, here, by contrast, 4 deliberating jurors attest that there was a final unanimous agreement that Miss Reed is not guilty of second-degree murder, persisting through the conclusion of deliberations. According to one juror, Jurdy, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and count 3? Most importantly, unlike Blueford, this was not a case. Oh, dude, like my video. Y'all, like my video. Unlike Blueford, this was not a case where the defendant was charged in a single count, which incorporated lesser included offenses. You guys, squirrely crystal ball strikes again. Indeed, the Arkansas law at issue in Blueford, dude, and I said this, literally. I was going to say we have it on video, but we watched it on video even tonight already because, like, that's it. Dude, yes. Did not even permit the jury to return partial verdicts of acquittal. Yeah, it's not. You guys, I've said it before, I'll say it again. What they're pointing out here is same thing I was saying. They're saying this case law that the Commonwealth is relying on, Blueford is like their main thing that they're relying on, right? They're pointing out the same thing I pointed out, which is it's not on point. No pun intended. That was a happy accident. It's not on point. And remember, if it's not on point, it doesn't count. Okay, it has to be on point. It's not on point because they're talking about only one charge. In another, like, it's really kind of insane, right? That they would even bother to cite it. The Commonwealth. I'm referring to them. So crazy. But if they're citing it, it means it must have been the best thing they could find for their argument. So that should say something as well. Noting that the jury's options were limited to 2, either convict on one of the offenses or acquit on all. Here, by contrast, and this is in italics, guys, here by contrast, the defendant was charged with 3 stand-alone counts. Y'all, how many times have I said that? Remember how many hours we discussed this when we were doing the jury instructions and the verdict forms? And I was trying to explain that counts 2 and 3 are not lesser included for count 1. They're 3 standalone counts. Do you guys remember the boat days, the boat times? They're 3 separate counts, right? And all the lesser includes are attached to count 2. We went over that so much. I tried to make sure no squirrel was left behind on that. That the lesser includes have to be attached to that particular charge. 3 standalone counts. And I gave some examples that I think were really terrible, but I tried my best to think of examples of, anyway, how that could work. So hopefully it all made sense. Here, by contrast, the defendant was charged with 3 standalone counts, and state law expressly allowed for partial verdicts on any charges with respect to which the jury was agreed. Only if the jury, in fact, was deadlocked on all 3 should a mistrial on all 3 be declared. That's key. I'm going to say it again. Only if the jury, in fact, was deadlocked on all 3 should a mistrial on all 3 be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. Now, I know what you might be thinking. If you're the Commonwealth, or if you're trying to imagine what the Commonwealth will be thinking, that they're going to be like, well, you didn't say anything. You didn't bring this up at a time. You didn't argue, blah, 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 right? So let's see if they address, I'm sure they will, those concerns. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth, unsurprisingly, cites no support for its contention that a deadlock on some but not all separately indicted charges supports declaration of a mistrial with respect to all counts. Contrary to the Commonwealth, actually, let me do this footnote first. That's footnote 2. I agree, Blackwater. Sorry, I have not been looking at the chat. Dismissal in what way? Dismissal of the charges. Let me say this. Hopefully you're still listening. So let me say this, that remember, oftentimes what would happen, guys, is if there's like, let's just say that it was a regular trial or not. Well, okay, let's just say that it was the same trial, but Judge Bev pulled the jurors, right? Okay, actually, no. Okay, yes. Let's just say it was the same trial and the jurors were pulled and it came out that they were, let me think of a way to put this. I'm trying to think of a way to put this that all makes sense. Okay, let me do it. Let me say this. Let me say it this way. Okay, let's say everything in this case is the same. And let's just say, though, that the only issue was that, let's just say that there wasn't any issue with the jurors and the unanimous verdicts. Let's just say that the issue that the defense had was that they weren't given time to consent. Let's just say that that was the only issue, just for the sake of example, okay? And that there wasn't this whole other separate thing of the unanimous verdict and whatnot, okay? And that it was just the fact that they didn't get to consent, okay? The normal remedy that would be happening in a motion such as what the defense filed would be for a would be a mistrial where it would just be retried, right? Like, which is what is already going to be happening anyway if the Commonwealth chooses. Like let's say that she'd been convicted, okay? But then the defense made this motion because they said, hang on, you know, you declared well, that wouldn't, see, this is what I'm trying to think of an example. So, have to be a situation where she was convicted. Let's say she was convicted on, okay, yes, okay, here we go. My brain worked it out. Let's say she was convicted on one of the counts, any of them, okay? And the jury was like hung on the others, okay? And the same thing happened where the defense was like, we didn't consent to declaring a mistrial on the hung charges, okay? The split verdict. The remedy would be saying, okay, that's fine. You can like have a mistrial, right? Like essentially the difference here is that the defense isn't asking for a mistrial. They're asking for the charges to be dismissed. So in terms of dismissal, because Blackwater was asking, the dismissal is different because the dismissal means they drop the charges. It's the same thing as like how the Commonwealth doesn't have to retry. Like the dismissal of charges could happen in a number of ways here. I'm not saying they will because of who we're dealing with. But let's say this was a different state. For example, Alec Baldwin, great example. His charges were dismissed, right? So that was what happened. That was a sanction towards the government for fucking up. So here, same, right? Like the defense has made a motion to have her charges on counts 1 and 3, those 2 counts dismissed. So dismissal could happen either if Judge Bev, right, grants their motion, which is probably unlikely, but she could grant the motion to dismiss. Or alternatively, dismissal could happen if the Commonwealth realizes that they're being stupid and they're idiots and they just drop the charges, right? Now those all, and even in Baldwin's case, those are all different from an acquittal because an acquittal can only happen when there's been a verdict reached either by a jury or a judge as like in a bench trial. So an acquittal can only happen when somebody's been found not guilty. Dismissal doesn't mean you've been found not guilty. It's just the charges have gone away, if that makes sense. Okay, cool. So, okay, cool. So only if the jury, in fact, was deadlocked on all 3, should a mistrial on all 3 be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all. Oh, I know what I was doing. I was going to look at that footnote. Okay. Footnote 2. Hold on. Okay. That's what we were doing. So footnote 2. Is anyone going to know that we acquitted Karen on counts 1 and counts 3? Okay, let's go read this footnote. The contrast with a Juvenile v. Commonwealth is even clearer. There, after the conclusion of trial, a court officer had picked up 4 verdict slips. Oh my God, dude, this is exactly what I've been asking, right? Guys, remember when we talked about this? Let me zoom in. This is exactly what we talked about the other night. We said, what would happen? Would a janitor go in the room and find the verdict slips? Do you guys remember? I can't even believe this is in the case law. Holy shit. Because it seems like this had never been, in my mind, it's like this is a new issue, right? Remember, you're like, wouldn't someone have gone in and seen the slips, right? Would some janitor have found the slips? Like, what would have happened to the papers? Did anyone ever see the papers? Dude, look at this. Wow. There, after the conclusion of trial, a court officer had picked up 4 verdict slips from the deliberation room, 2 of which reflected entries of not guilty. There was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. So what they're saying, because the Commonwealth was citing this case, they're saying this is different because we don't know when they came to that conclusion and we don't know if it was unanimous. So they're saying it's different. But it's, in my mind, what's crazy is just that there's talk of verdict slips being found in the room after the fact. Because I still want to know what those slips said and if somebody saw them. Anyway. Also, just saying, if anyone, by anyone, I mean the Commonwealth, is going to make this argument that they're invading the province of the jury to ask if they were unanimous, well, one solution to that would be to be like, hey, what did the verdict forms say, if anything, right? Anyway. Okay, so, right, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of mistrial with respect to all counts. Contrary to the Commonwealth's characterization as unambiguous, and then they're citing the opposition again, the jury note at issue here was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse to all charges, or two, that the deadlock applied to only some of the charges. So I think a distinction here also, just to break this down in terms of the way I think what is going to be a part of what matters here, is like in some of this case law that the Commonwealth cited, from what it sounds like to me is this. It sounds like either there was only one charge, in which case it's not on point because it's not dealing with multiple charges, or two, like in that last example we were just reading in that footnote, that there were multiple charges. However, the jury had a verdict on one of the charges and turned that form in, and then they were sent back with the other forms for the other charges to continue deliberating, and then they were deadlocked. So that there's a difference in the timeline. Because remember, part of the issue here, there's a lot of things, but one of the issues that is of concern that will be argued by the Commonwealth is that when was it unanimous, right? Because that's one of the things is like, well, if you give them an instruction like the Tui Rodriguez, right? Or if you say to them, oh, we'll take one verdict and then go back and try on the others, that you're going to end up with like a tainted verdict because they're going to feel pressured to have to come to a verdict. And then those charges would then if there is a verdict or whatever, it's like not as valid, right? Or could be considered tainted. Again, this is the fear of the Commonwealth. So they're making another distinction that in this case, there were no verdict forms collected at all. So it's not like any not guilties if they were marked on counts 1 and counts 3, if they were marked on those forms at all. It's not like those were only in response to having something else collected and being under pressure, in other words. So I think that's part of it. The information received from jurors post-trial proves the latter interpretation was correct. So the latter interpretation, which is the part about the deadlock, right? That's the point, that the jurors even said that they were right. In other words, the judge interpreted impasse, as I said, which is subjective. She read it wrong. She assumed it was all charges, but they learned from talking to the jurors that it was on charges because they were confused by the languaging, and charges was in reference to count 2 with lesser included charges. And my brain can already see where this is going to go, and where this is going to go is whose responsibility is it to ask the questions, but we'll get there. So the information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction. And this is what we've already said as well, guys. We said this. Because we kept saying those jury instructions are clear, dude, that it should continue deliberating until it had reached a final verdict on each charge. Yep or do. Given that there was no deadlock on 2 of the 3 counts, it follows that there was no manifest necessity to dismiss the jury without receiving its verdict on those 2 charges. The defense does not suggest that the court was required to give the jury, quote, new options for a verdict, only that it should have asked the straightforward question of which the separate indictments the professed deadlock related to. And here's the thing is, according to Rule 27B, she fucking should have done that. In essence, the Commonwealth's contrary position asks this court to close its eyes to the possible, or even as here very likely, existence of partially unanimous verdicts on some but not all separately charged accounts to avoid the risks of juror coercion. And that's exactly what I was just saying. The thing I was saying about the problem with if you accept one verdict and then have them go back on others, that's the thing, right? That pressure, that's the risk of juror coercion, where then a verdict could be tainted. That's what I was just saying. Keep reading, Chelsea, right? The Commonwealth utterly fails to acknowledge that Roth, Blueford, and a Juvenile are all clearly distinguishable because they all arose in the context, again, dude, crystal ball. Lesser included offenses. Sorry, hold on. Let me say that again. The Commonwealth utterly fails to acknowledge that Roth, Blueford, and a Juvenile are all clearly distinguishable, as in not on point, because they all arose in the context of lesser included offenses contained within a single charge. As in, there was only one charge with lesser included offenses. Let me tell you how this would be on point. Let's say if Karen Reed only was charged with count 2, that was her only count, in which case it would be called count 1, right? But that was it. Count 2 with the lesser included within count 2. And that was her only charge. Then it would be on point because then it would be the same as these other cases that the Commonwealth cited. However, the problem is the Commonwealth cited these cases where there's only one charge, right? Honestly, they should be embarrassed and ashamed of themselves because it's really disgusting in my opinion. Like, dude, really? That's the whole point. The whole thing that's at issue is the fact that she had more than one charge and you're going to cite case law. Anyway, I could go on. The Roth court's concern, instead I'll keep reading. The Roth court's concern about coercion makes sense in that context. When the jury reports a deadlock on one charge, follow-up questioning regarding the possibility of reaching a verdict on the lesser included offense would imply that the jury should consider conviction on that lesser offense. Yep, that's the coercion thing. But this logic does not extend to the present circumstances. Again, it's not on point. And no existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges, such as those in the current indictments. Let me say that part again. No existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges, which is what we have here. This is really strong. This is even stronger, I think, than the first one. This is really strong. They took a little bit more time, though. They pumped that first one out, lickety split, and they took a little bit more time on this one. And I think that just gave them maybe some more time to find some even just stronger case law. I'm looking at this case law here, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. Right. Yes. Oh, look. Mass crimp 27. Yep, we know that one. We know that backwards, forwards, and inside out this juncture. And there's the reporter's notes. You guys, they did it. Finally, they did it. They did it. Let me pull up my video. Hold on. They did it. Finally, thank God. Y'all, you guys. The way that I'm so happy I could cry. The way that let me just say, I was at the grocery store today and I was looking at the lettuce. And I was looking at the lettuce to pick out the lettuce. And I couldn't even concentrate to pick out the lettuce because all I could do in my head is think to myself, why the fuck has the defense not? And I hadn't read this yet, okay? I was still thinking about the first one, right? And I was also thinking about the Commonwealth opposition. Like I said, I've been thinking about this ever since these came out. And I'm just like, why the fuck is the defense not relying more on mass crimp 27B, as we learned from Dr. Bob? No one else fucking knows about this shit, which is wild to me. But we knew about it because of Dr. Bob, and we read it billions of times. And just to reiterate that, let me pull up my little video again and go to a specific spot here because I'm so happy right now, you guys. I'm so happy. I'm so happy because I'm like, in my mind, I'm like, am I just confused? Because to me, I'm like, this is the highest, most binding, mandatory binding authority that there is for them because this is a statute. And why are they not using it? Like, I'm like, am I just misunderstanding something? Am I confused? Or do they just not know about it? Because I'm like, do I need to be worried? I mean, really? Okay, so let me just find this spot about that here in this little video. This is from last Friday. Charge. And that's a completely different situation. For example, if there was only one charge, yes, there's no need to inquire. It says here, the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. Yeah, you guys, literally, I have not heard anybody on LawTube talk about this rule. I did. The closest I saw was maybe a week ago. Somebody paid a super chat for Lawyer You Know, and the super chat was like, please, can you cover Rule 27B? And he was like, maybe if I get around to it. Never happened. That was the only time I've even seen it mentioned on, and I love everybody on LawTube, as y'all know, but nobody knows about this rule, man. It's only because of Dr. Bob do we know about it. But yeah, I just wanted to say, but like, I've just been in my mind, y'all, it's been keeping me up at night. Like, why are they not saying? Because I'm going to show you guys exactly what I mean from this video. Let me find the right spot. That they were deadlocked, right? charges. In my opinion, of the 4 issues they stated here, the only one that holds is this one that is in sent to the mistrial. That's the one where there is contradicting cases. The rest of these 4 prove, in my opinion. Here, Massachusetts law to the contrary clearly. Okay, this is what I was gonna. Y'all are gonna hear me say this from on Friday when this live stream happened. Okay, this is the part that has been keeping me up at night. The part that got me stuck in the lettuce aisle. Okay, this footnote 2, and you're gonna hear me say it in the video here in a second when I play it. I just wanted to reiterate. This is footnote 2. This is all that they had cited previously with Rule 27B. And again, I've been pulling my hair out over why the fuck did they leave out the most important part of this rule? Why? Am I stupid? Like, what is happening? Like, why the hell did they not bring up the split verdict thing? That was the whole thing Dr. Bob had brought to our attention that was so relevant. And it is binding, dude. They can't not do it. Like, it's so obvious, right? And I'm like, what is going on? And so here, let me play this part. But it clearly permitted the jury to return a partial verdict on some but all counts. And that there's 27B. Now, what's interesting is they didn't cite it for the part that I think is the most important. I mean, what do I know, right? But like they at least though did cite it. And where they have it is a footnote here. So there's the footnote. Declining to require court to consider the jury new options for a verdict in the form of partial verdicts unless they're included offenses, where under Arkansas law, the jury's options were limited to 2, either convict on one of the offenses or acquit on all. Which really, they're using the part about Blueford here, which was also brought up in Rule 27B under the reporter's notes, but that's not the part that matters, man. Do you guys see what I mean? Like, you heard it there. I was like, well, they didn't cite the part that I think is important, but what do I know, right? But at least they cited it. But that was me being optimistic, because after I made this video, it's been literally just eating me alive of like, why is nobody talking about this? Why is no one on law keep talking about it? And why is the defense not using this? Right? And I'm like, what is happening? I can't tell you guys how relieved I am, y'all, because they finally look. Oh my God, I'm just getting goosebumps again. Oh, thank God, because I'm just, y'all. Oh my God, here it is. Where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts, providing that the court may declare a mistrial in cases where the jury is unable. This is it. Providing that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. That's it. Y'all have heard me say this a billion times. I know you're sick of it. I'm just, here it is finally, y'all. Dude, did they hear the squirrel call? I don't even know. I'm so happy that they finally said, because dude, this is what, I'm like, where is it? What? Like, this is not unclear. This is not confusing. This is clear. And it was so clear that literally when the mistrial happened, I out loud on live stream was like, hey, hang on. Why didn't she follow the thing? Why didn't she do the things? Why didn't she ask the jury? And I even made a joke about how we spent hours on it and she didn't even do it. Dude. There it is. There it is, guys. Y'all. Squirrel Crew is the best. Just have to say. Dr. Bob, you just found us in at the right time, man. All right. So, however, it must first receive and record the verdicts which the jury can agree upon. Thank God they cited this. That's all I can say, because literally, I don't know, my sanity was being affected. There's simply nothing coercive about asking a jury reporting a deadlock. Yes, correct. I've said the same thing. That fails to specify which counts the deadlock relates to the single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts. There's nothing coercive about that. And they're going to be getting into I would assume they're going to be getting into this whole thing about the problem. Is it going to be invading the province of the jury if they do an inquiry? They're going to have to do an inquiry. I mean, fucking hell, Judge Bev's going to try to not do it, more than likely, right? But like how? You have to do an inquiry. You have to. Anyway, We all know that reasoning is not, unfortunately, the way that that court has operated in the past. So, affirming trial judges taking of partial verdicts on 2 of 4 separate indictments and observing to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant into final ones and to abandon all doubts that they may have privately entertained runs counter to the clear instructions of the judge and amounts to mere speculation without any support in the record. Affirming partial verdicts taken after the judge asked the jury whether it had reached a verdict on any of the indictments. Yeah. Well, it's not even unclear because it's stated right there in the criminal statute. So the inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able once and for all to conclude their confrontation with society through the verdict of a tribunal they might believe to be favorably disposed to their fate. Again, this is going back to that same thing. Honestly, now we understand it better, right? Going back to the Crown. The idea that the Crown could just be like, oh, we don't have enough evidence. Let's get rid of this jury and find another jury that's going to be like, yeah, we'll convict a ham sandwich or whatever, right? You know what it is, dude, is like what Lally needed. Lally needed a jury that would see those fucking solo cups and be like, you know what, that's fine. We'll convict with this, even with the solo cups. That's what he wanted. That's what he needed. That's why double jeopardy exists, guys. That Lally doesn't get that fucking chance to find a jury, if one exists, that would convict her amongst the red solo cups. And the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone counts. The Commonwealth attempt to shift blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. The defense's request for a Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts. Yeah, of course. Nor did it commit the defense to any position. Yeah, I agree. Regarding whether the court should sua sponte declare a mistrial. Yeah, that's logical. That's just logic, right? But not everyone has it, unfortunately. A discussion with counsel such as that occurring twice earlier in response to jury notes and either the consent of the defendant to mistrial or further judicial inquiry of the jury instead was required. It is indisputable that the court provided no opportunity for defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez instruction. So that's good. They're just shooting down the Commonwealth's argument here, because remember, the Commonwealth was like trying to, the Commonwealth spent the vast majority of their stupid opposition. Sorry, I just have to say it like it is. Talking about the events leading up to Monday, but it spent the vast majority talking about like, what was it, like Friday, right? The first half of it was like the first 2 letters and the whole thing about the Tui Rodriguez instruction, right? And they even spent like several paragraphs quoting Yannetti. And when Yannetti was talking about the Tui Rodriguez instruction, which is just taking up space, but anyway, they're saying here that whether or not they had plenty of time to discuss the Tui Rodriguez instruction is irrelevant. That's not the point. And the defense is not arguing that they didn't have enough time for that. It's irrelevant. It's a red herring, as it were, right? Because that's not the thing that's at issue. It's the declaring of the mistrial. And as we know, it was 4.65 seconds. In short, mere silence, absent an opportunity to object, does not amount to consent. The cases relied upon by the Commonwealth are readily distinguishable on this basis or even support the defense position. I agree. I actually pointed those out. And I'm wondering if I did, I might maybe didn't even notice these to include them in the video that I made, because I actually did point those out where there were some in the defense's, in the Commonwealth's opposition that I was like, wait a second, that seems to support the defense. But that's not surprising, right? Because isn't that what the whole trial was? holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from defense counsel cannot be construed as consent to such action. The judge declared a mistrial upon the defendant's request, blah, blah, finding that the defendant plainly had the opportunity to object, where the mistrial was declared after a voir dire and colloquy after the jury were cleared from the courtroom. So again, distinguishing it, saying they were given lots of time to talk about it, discuss it, blah, blah. In only one case cited by the Commonwealth, Fuentes v. Commonwealth, was the defense, as in the present case, afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth failed. This is important. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of a mistrial expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. Bam. I remember reading Fuentes because I remember saying, Fuentes, wow, that's interesting. That looks like one of the strongest case laws for the Commonwealth. And I even said, I'm going to write it down and make a note. And I did write it down and make a note. And I was like, we're going to have to look into this. I remember it. And I heard it when I was going through and clipping the parts for that video that we already watched. And I was like, Fuentes, I still need to go through that. Because that was one of their strongest things. And so here, the defense is saying, this was the case that was most on point, right? Only one case cited by the Commonwealth, Fuentes, was the defense, as in the present case, aka on point, afforded no opportunity to be heard. But then they're distinguishing it by saying the Commonwealth fails to mention that in the jury note, in the case of Fuentes, in the jury note, the jury said they couldn't reach a unanimous verdict as to either. Sneaky, sneaky snakes. Dude, that's Slimy. Weasel alert. Hold on. This is, y'all, Weasel alert. Weasel alert. Because that's so gross. Hi, Super Planner Girl. I just saw you're here. I've not been looking at the chat. I'm glad you're here. Did you just rage clean your daughter's playroom because of things happening in Karen Reed or what? But glad you're here. And yeah, but the weaselness of this thing, though, that they did not mention that the fucking jury note in this Fuentes v. Commonwealth case said either of the two indictments. That's so disgusting. It's disgusting. It's shit like this, man, that makes me wish I could have another life and be a defense attorney. Because this is disgusting. I am disgusted. I'm just disgusted. I'm just disgusted. And at the same time, I need to say that I'm grateful that in other cases, justice has been served where there's been fuckery on part of the government. And by which I mean, finally, Judge Fuckhead, as I call him, out of Georgia, no offense, Super Planner Girl, has been recused from the YSL RICO trial. And also in Alec Baldwin's case, that, again, the fuckery that was going on with the government, the judge said, nope, not on my watch. You're done. So I have to say I'm grateful for that. That is important. It's really important. But between that, like those things happening correctly and then this case happening incorrectly, all that still, it just, dude, you know, here's the thing, guys. Quick tangent, real quick. Because my whole life, I feel like, and probably everybody, here's this whole thing that there's this stigma, right, about defense attorneys being slimy. Does everyone raise your paw, right, or hand? You know, if you've all heard this, right? Defense attorneys are slimy. Defense attorneys are scum. Defense attorneys are whatever the fuck, greasy, whatever it is. You know? Everyone hears that, right? And it's like, I was thinking about this the other day. I can't think of a single case. I'm sure probably they exist. I can't think of a single case where there has been fuckery to the level of like a gross miscarriage of a gross injustice. I can't think of a single case where that's happened from the defense. Not one. There's been no falsification of evidence. There's been no, I mean, just blatant, like, dude, the fuckery that's been happening in these cases, all of it has been the government, whether it's the judges or the DAs or the prosecution or all three in cahoots. Law enforcement, actually throw them in there too. Government, right? Government. Every single thing. And it's like, hang on, what? And it really makes you sit there and think, is this all just because of some misconception, some bias that people have? Like, where the fuck did this whole thing come from? Of like, it's the defense attorneys that are greasy and the prosecution like is doing the right thing. Like, dude, if you actually just look at the cases, it's the opposite, man. It's wild. So where did this whole thing come from? And now I'm like, fuck, I feel bad because my whole life, I mean, you know, as an adult at least, and you know, whatever, for many years would I've been in that pile of people who think there's this assumption that defense attorneys are slimy, right, man? Yeah, paws raised. Good job, guys. What did you hear the other day with EDB? I'm sorry that your life is causing you to rage cleans for Planet Girl. But yeah, so, but you guys see what I mean though? Like, what the fuck, man? I feel like we've been, you know, collectively kind of like sold a, you know, it's just another one of those fucking things. It's like, it's just like being sold, I don't know, anything else, right? I could go keep going on this train of thought. I don't think I want to, but you know, I'm thinking of like billboards and advertising and Super Bowl and all the bullshit, right? And it's like add this to the list of the bullshit that we are constantly exposed to as Americans without even realizing it. Add to the list probably the worst of all of it, which is that everyone's got this idea, right? And Black Widow's not even an American. She is the same thing, right? Everybody, right? That defense attorneys are slimy. And yet I can't think of a single fucking example. I mean, even take Putin, Jim. Dude. You can't even compare it. You can't even compare it. Because there's nothing that they did or even would do that would even come close to anything we've seen in terms of the shit that's been done with Karen Reed, with fucking Carrie Morrissey, right? With well, I guess by Karen Reed, let me just back that up and say all of the shit that's been going on in Massachusetts, right? Because it's not just her case. With the YSL RICO trial and others, right? Richard Allen, right? That's just off the top of my head. It's like, I can't think of any defense attorney that even if they were annoying or even if they were involved, it's like they wouldn't even, I feel like they wouldn't do it because of the ethical reasons, right? And it's like, fucking hell. It's like being fucking gaslit, man, in a way, to just go ahead and just trust that the government is automatically doing everything right and the defense is doing everything wrong, which is interesting, right? Because then at the same time, we're supposed to believe innocent until proven guilty. Anyway, that's a whole existential sort of, not existential. I don't even know, man. That's like I could go on a whole philosophical train of thought and try to break this down as to what is going on there. But anyway, oh, well, Alec, oh, right, Murdoch. Okay. I guess I wasn't counting him because he was on trial. Right. He was this, right, exactly. Yeah, yeah. We're talking about, yeah. So that's different, but also we didn't watch him represent anybody in a case either. So yeah, I don't even think of him as an attorney anymore, obviously. I was just thinking about Dick and Jim, right? Because they were the defense attorneys in that case. And it's like, you know, they were, you know, whatever goofy and funny things and whatever, or annoying, whatever the case is. It's like, there wasn't anything that they did that was like, I can't think of any defense attorneys from any case that I've ever seen or heard of or any trial where they they did anything that even would come close to the shit that we've seen on behalf of, again, law enforcement or the prosecution or the DA or the Commonwealth or the judge. And I'm saying that to cover the bases on all those different cases I just mentioned. So, and when you think about it too, it kind of makes sense, right? Because the government is responsible for all the discovery. So it's really, they're the ones that have that opportunity to fuck with it, right? And they're also the ones that are in charge of the investigation. The defense isn't. And when you think about that, that's a whole other thing, right? The defense only gets what is turned over to them. Like, they're handed, here you go, pile, right? From the government. And it's like, all right, well, should we, it's like, is our first job to just assume all this was done correctly? Nope. And that now when you think about it that way, you can see why it's this whole thing of like the common strategy of the defense is to poke holes in it, because that's the first place you should be starting anyway, right? Dude, anyway, I could keep going. So, all right, let's get back to this document. I just think that a lot of this stuff for me, it's a bigger picture thing of like shit that if I really get thinking about it, it would make me feel like I need to stop everything and become a defense attorney, because like, it's like, how can I not, if I really allow myself to go there, you know what I mean? All right. So, right. But this is where I got pissed off. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of a mistrial expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. That's when I was like, oh, there's just Slimy. That's, yeah. Okay. In those circumstances, while the more prudent course would have been to consult with counsel, the record did not show that such consultation would have produced any fruitful alternatives. Here, the opposite is true. The note did not expressly state that the deadlock applied to all counts, and it is patently clear from the affidavits submitted in support of the defense motion that consultation with counsel may have well produced a fruitful alternative, namely inquiry regarding whether the jury had reached a unanimous verdict on any of three counts, which, according to the information from jurors A, B, C, and D, would have resulted in acquittals on counts 1 and 3. In any event, Fuentes did not alter the court's clear obligations, repeatedly reaffirmed since that decision before declaring a mistrial. So 1, counsel must have been given the full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. The Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not dude, this is fucking old. This is a stick burn right here. I'm gonna read this one again. Stick burn! Shout out to Marty Weinberg. The Commonwealth cites no support for its suggestion. This is so funny because the suggestion in and of itself is funny, and then they didn't even cite anything to back it up, which this is funny. Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not act upon that information. The jury's agreement that Miss Reed is not guilty on counts 1 and 3 reflects the, quote, results, end quote, of its deliberative process, not the contents of jury deliberations or thought processes of jurors. Right. They're saying it's the result, not the deliberative process. And that matters because of that whole argument about invading the province of the jury. Remarking that the trial judge was rightly loath to examine the entire panel to attempt to determine the impact of the errant juror on the rest of the jury. The defense is not relying upon jurors to attest to any particular statement made or incident that occurred during the jury's deliberations or anything, or the effect of anything on any juror's vote or any juror's mental processes concerning a verdict. Rather, the defense is relying upon the simple fact of the jury's agreement that Ms. Reed is not guilty on the relevant counts. Yeah. And this matters because, like, this is what I said too when we were talking about this on the opposition. Like, they don't need to inquire to get into the province of the jury's deliberation, right? Because that's what the Commonwealth's going to argue, right? Because that's the obvious argument. Province of the jury deliberations, right? I get it, right? However, all they have to do is this. Were you unanimous on this count? Yes or no? That's it. One question for each juror. And you know what? That does not require invading the province of the jury deliberations. So anyhow, And then here it says, permitting juror testimony that a mistake was made in entering the verdict on the verdict form. The permissible subjects of juror contact listed by the Commonwealth are not exclusive, and the Commonwealth fails to cite any authority establishing that the fact of a jury verdict constitutes a prohibited subject matter under rule. Oh, that's good to know. 3.5c. So that's good to know. In other words, they're saying that there's no, Commonwealth has not cited any authority to say that it is expressly prohibited under a statute, like a Massachusetts statute, right? That it's expressly prohibited, that they cannot simply ask about a verdict after the fact. That's not off limits, which makes sense, right? But in other words, there's no case law to say otherwise. So that's good to know. At the same time, that the Commonwealth criticizes the defense for purportedly infringing upon the jury's deliberative process, it also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel attesting to alleged juror bias was no less hearsay. And the Supreme Judicial Court squarely held that it entitled the defendant to further inquiry on the subject. The defense submits the same result as warranted here. So that's interesting. This might be another good one to look into. Because there's a similarity here in that there was an affidavit made by counsel. This is a unique situation, right? Where you have these affidavits that we have, right, from Jackson Unetti. That's not common, right? That you have these affidavits in support of a motion and then they bring in another attorney. So that's where that's where there's the potential hearsay issue, right? So that's why this is on point here. Good job, defense, because they say it's the same thing, right? Affidavit by counsel. It was no less hearsay, and it was held by the Supreme Judicial Court. For all of the reasons set forth above, as well as in its opening motion, supplemental memorandum, and attached affidavits, the defense respectfully requests that this honorable court issue an order dismissing counts 1 and 3. Respectfully, all the people. But right now it's Marty Weinberg. So I think this is very strong. I mean, let me see what you guys are saying in the chat. I mean, the thing is that it's going to matter. You know, it looks like there's going to be another judge on the 22nd. But I think what we ended up realizing is that it doesn't look like they're going to be arguing these motions then, unfortunately. Well, I'm saying unfortunately because I want to get to see it. But like, I don't know. I guess it would, well, yeah. It sounds like that judge is going to be a better judge, right? But like, again, it would make sense that they're not going to argue something like this in front of a different judge. That wouldn't make any sense unless they're planning on fucking swapping Bev out, which, hey, are they coming to their senses? I don't know. But wow. I mean, it's just, there are a lot of really good points in here. And let me go back. Where was the part about manifest necessity? Because I remember thinking I wanted to come back to that. Here. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports Depp. Okay, I remember this part. Contrary to the Commonwealth, characterization is unambiguous, blah, blah. Right. This part about the jury instructions. The defense does not suggest, let me zoom in. The defense does not suggest that the court was required to give the jury new options for a verdict, only that it should have asked the straightforward question of which of the separate indictments the professed deadlock related to. Where was the part that where they put, they cited, there it is, 27B. Yes. I would have maybe even included that part on the previous page, but whatever. Because I think this has less to do with the whole thing about coercion and pressure and more to do with where was it? Actually, I guess 2 pages back. Oh, here. Oh, here, right. They also cited here. Okay. Right. But they don't actually explicitly say what it says. So that's why that was not. Okay. Yeah. Here's the part. After this is where I would have actually, if it were me, after this part, because Blueford is the Commonwealth, well, they think it's like one of their strongest case laws, but it's not on point, so whatever. But anyway, they think it is their strongest. But that's why they have to argue Blueford a lot. But like that's why after here, where they're citing Blueford again, the defense does not suggest that the court was required to give the jury new options for a verdict. And then here's the citation for Blueford. Right, let me zoom in for Blueford. Only that it should have asked a straightforward question of which of the separate indictments the professed deadlock related to. That is where, if it were me, that's where I would have stuck this actual citation right here from Massacre of 27B. That's where I would have stuck it, because they have it here and it's talking about coercion and stuff. I mean, to me, it's just that, thank God it's in there, right? But I would have stuck it right here with this part about Blueford. Anyway, but I don't know anything. So, but yeah, this is very strong. Okay, one other thing I wanted to do. So what I wanted to do is look at this. Okay, I wanted to look at this real quick. So I think this is relevant because this applies to everybody that's in law, right? So the attorneys, the judges. So whether you're Carrie Morrissey or DA Morrissey in Massachusetts, or whether you're Judge Bev, or whether you're Lally, right? Judge Glanville, any of these people, right? All this applies. So this is the shit that everybody treats as gossip. Like, it is a big deal to break this shit. It's a big deal in a lot of ways. It's like, it's not just a big deal because you get in trouble. It's like undermines the profession, right? You know how people felt about it with Alec Murdoch, right? They took it deep within their soul. This is why, because this shit is so ingrained to everybody when they're going through law school, they're training for the bar exam or studying for the bar exam, all of it, right? This is like a huge part, believe it or not, of what they're learning is actually this. They really hammer it home. So, so let's look at, ooh, people have been asking about this. Let's just look at this real quick. Declining or terminating representation. I know we were talking about this the other day with like, when can you fire an attorney and stuff? A lawyer shall inquire into and assess the facts and circumstances of each representation to determine whether the lawyer may accept or continue representation, except as stated in paragraph C. A lawyer shall not represent a client or where representation has commenced, shall withdraw from representation of a client if the representation will result in a violation of the rules of professional conduct or another law, the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or the lawyer is discharged. So in other words, if they're fired, basically, right? They can be fired. This is what I was saying the other day. Like, in other words, you can fire your lawyer. It's a lot harder if you're the lawyer to say I'm firing the client, right? The client or prospective client seeks to use or persists in using the lawyer's services to commit a further crime, right? That's that thing of like, if you are complicit because you know that there's crime happening or whatever, despite the lawyer's discussion pursuant to rules, blah, blah. Yeah, okay. Except as stated in paragraph C, a lawyer may withdraw from representing a client if withdrawal can be accomplished without material adverse effect on the interests of the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. The client has used this lawyer's services to perpetrate crime or fraud. The client insists in taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. The client fails substantially to fulfill an obligation regarding the lawyer's services. The representation will result in an unreasonable financial burden on the lawyer, or other good cause for withdrawal exists. So it has a whole long list, and then it says or. So just to be clear, it means they don't have to have all of these, any of them. One or more, they can just have one of these, right? And that's when they can withdraw. A lawyer must comply with applicable law requiring notice to or permission of a tribunal when terminating a representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. Upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interest, such as giving reasonable notice to the client, allowing time for employment of other counsel. And we see that, right? They find somebody else. Surrendering papers. Yep, we've seen that. Okay, cool. So okay. All right. That really applies more to civil. Okay, let me go to the next one. Advocate. All right, guys, this applies to everybody, right? Again, judges, lawyers, all of them. A lawyer shall not knowingly, 1, make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Tribunal is like the court, right? 2, fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Now that is important. So what that means is this. So where it says legal authority, right? Every time you guys hear me talk about mandatory binding authority, that's your legal authority, right? In other words, if they are doing research for their case, it doesn't matter which side you're on, right? And you find legal authority that is bad for your side, but it's like it's what has to be followed, right? It's like the mandatory binding authority. Like you have to disclose that. You can't just ignore it because it's bad for you. 3, offer evidence that the lawyer knows to be false. Let me say that one again. Offer evidence that the lawyer knows to be false. I don't think that would apply so much to. Okay, let me just say, of the 4 cases that I've already named tonight, I think this applies the most to Massachusetts. Because that's where you've got a lot of issues with the evidence and the investigation. Like, of course, with Baldwin, it was a violation, a Brady violation, right? But that's different than false evidence, right? Like solo cups, for example, or like, there's just the list would go on. I'm not going to bother in terms of Karen Reed. Like I would say their entire fucking thing was false, honestly. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So, like, if you're Lally, right, and you're doing the right thing, and you realize, oh, wow, like, everything that Trooper Paul has said is complete and utter bullshit, and we've just, held him out as an expert for this, and, like, we're, like, trying somebody for murder, and, like, holy shit, all that math doesn't make sense. He doesn't even know what physics is. Like, hell, let's just say that you're like, wow, like, if you want to do the right thing, right, you would, like, make it right by disclosing it to the court and being like, and then, like, taking the following steps to make it right, or whatever the next steps are. I mean, dismiss charges would be one way to go about it, right? A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. So this is here if you are a defense attorney. What they're saying is that if you think that there's evidence that's false, you don't have to offer it, right? A lawyer who represents a client in an adjudicative proceeding and who knows that a person intends to is engaging or has engaged in criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. The duties stated in paragraphs A and B continue to the conclusion of the proceeding and apply even if compliance requires disclosure of information otherwise protected by Rule 16. And in an ex parte proceeding, we know where that's relevant, right, guys? Georgia. A lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse. Okay. All right. Lawyer shall not, A, unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such act. B, falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. C, knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on an assertion that no valid obligation exists. D, in pre-trial procedure, make a frivolous discovery request or fail to make reasonably diligent effort to comply with a legally proper discovery request by an opposing party. E, in trial, allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence, assert personal knowledge of facts and issue except when testifying as a witness, or state a personal opinion as to the justice of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of the accused. Or F, request a person other than a client to refrain from voluntarily giving relevant information to another party unless that person is a relative of the employee or the lawyer reasonably believes that the person's interest would be adversely affected. Look at this one, though, letter E. In trial, allude to any matter that the lawyer does not reasonably believe is relevant. So, like, the score at the basketball game, the high top tables. Shall I go on? Or that will not be supported by admissible evidence. I know what I can say about that.
There's no evidence of anything in this case.
Okay, so good check mark there. Assert personal knowledge of facts and issue except in testifying as a witness. Well, I guess that would apply to Carrie Morrissey there because she did not testifying as a witness. Or state a personal opinion as to the justice of a cause. I feel like they've all done that wrong. The credibility of a witness, culpability, yeah. So, all right, let's keep going. A lawyer shall not seek to influence a judge, prospective juror, prospective juror, or other official by means prohibited by law. Communicate ex parte. Again, we got that going on more with other places like in Georgia. With such a person during the proceeding, unless authorized to do so by court order. Communicate with a juror or prospective juror after the discharge of the jury. If the communication is prohibited by law or court order, the juror has made known to the lawyer a desire not to communicate, or the communication involves misrepresentation, coercion, duress, or harassment, or D, engage in conduct intended to disrupt a tribunal. So for all the people who ask all the time, about jurors and the attorneys after the fact, right? And are they allowed to choose what happens, right? So remember, we always hear, well, the jurors can reach out, but they can't be contacted by the attorneys. So this addresses that issue here, right? They cannot communicate with a juror or prospective juror after the discharge of the jury if the communication is prohibited by law or court order. The juror has made known to the lawyer. That's where we always hear this, right? If the juror is like, no, leave me alone, they have to do that, right? The communication involves misrepresentation, coercion, duress, or harassment. I guess some could maybe say that was what was going on maybe with Poot and Jim to a certain extent. I mean, we know that they went to those jurors' houses. Anyway, yeah, okay. Go to the next one. Trial publicity. This is section. I don't think this is as relevant, although it would be interesting. All of these would be interesting to read, but they're just not all relevant to what we were talking about with these cases. Lawyer as witness. Well, this is relevant to Carrie Morrissey. Well, actually, and now that I think about it, Jackson and Unetti, just to the extent of the affidavits, right, with those jurors. So a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue, the testimony relates to the nature and value of legal services rendered in the case, or disqualification of the lawyer would work substantial hardship on the client. A lawyer may act as an advocate in a trial in which another lawyer in the lawyer's firm. I don't know. This is not what I thought I was going to say. Anyway, we'll go to the next one. Special responsibilities of a prosecutor. Oh boy. The prosecutor in a criminal case shall refrain, this is letter A, refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given reasonable opportunity to obtain counsel. Thankfully, that's not at issue currently in the big cases I've named as of tonight. However, it's an issue in plenty of cases. Not seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. Make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt. That's Brady violation right there. Yep. And in connection with sentencing, disclose. Yeah, that's getting into that whole thing. That's turning over discovery. Not subpoena a lawyer in a grand jury or other criminal proceeding to present evidence about a past client unless the prosecutor reasonably. Oh, okay. So this is like your 40, like your 404, like compensatory evidence, right? Character evidence. Like they have a tendency to commit other crimes, prior bad acts. That's what this is referencing here. because they're not supposed to be using that with only unless it's one of the exceptions. Except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement. When a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood, dude, this. Let me say this again. When a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall, 1, promptly disclose that evidence to an appropriate court or authority, and 2, if the conviction was obtained in the prosecutor's jurisdiction, that means if there was a conviction, right? Promptly disclose that evidence to the defendant unless the court authorizes delay. Oh, so all of these are when they've been convicted. Okay, convicted already. And undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted. Okay, so like this would be like, for example, in Hannah Gutierrez Reed's case, let's say that if in her case that evidence with the ammunition was just as much of a violation as it was for Baldwin and that they hadn't known anything about it, then we'd be more in this territory with that. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. How often do you think that happens, guys? Truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person or fail to disclose material facts to a third person. Remember, all this still applies to whatever type of lawyer, you know, and whoever you're representing. This would be relevant here for Murdoch, but you know, we've talked about that. Professional independence. So just practicing in your jurisdiction. Pro bono. I know there's a part in here coming up about judges and stuff. That's why I'm still going through it. Solicitation of clients. Oh, that's funny. So we know how that has changed over time in certain areas of practice, like civil, you know, plaintiffs, like, you know, Murdoch's firm and shit, or his former firm. You know, personal injury and shit. Aha, okay. Judicial and legal officials. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications of integrity of a judge, adjudicatory officer or public legal officer, or of a candidate for election or appointment to judicial or legal office. A lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Conduct. I think there's more. Reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. So in terms of with Baldwin, you know how the oh, I'm blanking on her first name, but Miss Johnson walked out, and there were some others as well. You know, she talked about it in her interview with Chris Cuomo. She has a duty. Everyone has a duty. Carrie Morris included. They all have a duty, the same duty. The ethical like they all are having to abide by what we're reading here, okay? And part of that includes they have a duty to not take part in this bullshit, unethical, that if things that are violating these rules. And not only that, they have a duty to report it. And if they a failure to report means they could actually get in trouble as well. So there could be fallout of this with Carrie Morrissey losing her bar license. We don't know. We'll see. But like, it could happen, dude. It could happen. And you better believe she was reported by her former colleagues. So they have to inform the appropriate authority. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises substantial questions to the judge's fitness for office shall inform the appropriate authority. So I think that everybody could go ahead and like report Judge Bev. This rule does not require disclosure of information otherwise protected. Oh, well. Well, okay, let me just clarify. Not everybody, right? You have to be a lawyer who's working with her, but yeah. In other words, we can't do it, unfortunately, Squirrels. It is professional misconduct for a lawyer to A, violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. B, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct that is prejudicial to the administration of justice. State or imply an ability to influence improperly a government agency or official. Blah, blah. Knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules. That could be applicable with the RICO trial. And then some discrimination there. That's if they go to get disciplined. Okay, and then that's the end of it. So there's a lot more. We didn't cover all of it, right? But we just went over parts that I think are relevant from what we were talking about with the fuckery, basically, right, guys? All the fuckery. So that'll do it for now. We'll see what we end up with tomorrow. It's always a surprise because it's entirely possible there will be some more filings that come out, right? It's also entirely possible that DSN will zoom through Depp Be Heard, and maybe he'll have made his way all the way to Spiegel. So we'll just see. But if none of those things happen, then I do believe we'll go ahead and do the next Karen Reed recap for week 9, which we've been kind of putting on hold as all this other stuff was coming out, and then putting on hold so we could take a little breather with a palate cleanser like we did. So that's about it for now, guys. But hopefully you guys feel like you learned something. And yeah, I thank everybody for being here and for being a squirrel. And I'll see you guys on the next video. And I'm going to go ahead and roll the outro.